Now we move our discussion to the fifth section, that is Golaknath case of 1967. We have seen Shankara Prasad case and Sajjan Singh case. Shankara Prasad case of 1951 and Sajjan Singh case of 1965. They actually gave similar kind of judgments, which actually said that the parliament has the ultimate authority to amend any part of the constitution, including the fundamental rights. The first point. And the second point is constitutional amendment acts do not fall under the purview of Article 13. So the constitutional amendment acts, even though if they affect the fundamental rights, they cannot be declared as unconstitutional or invalid. This is the thing, or this is the perspective that was taken in both of the cases, that is Shankara Prasad case and Sajjan Singh case. Now we are moving our discussion to Golaknath case, which is very important because in Golaknath case, a different stand was taken. A different stand was taken by the Supreme Court. So a kind of overruling of its earlier judgments, such as Sajjan Singh case or Shankara Prasad case. That particular kind of stand was taken in Golaknath case. Here, the subject matter under Golaknath case was 17th Constitutional Amendment Act of 1964. 17th Constitutional Amendment Act of 1964. We have seen in Sajjan Singh case also. In Sajjan Singh case also, the 17th Constitutional Amendment Act was challenged. There, the Supreme Court has upheld the validity of the 17th Constitutional Amendment Act and also said that Parliament is having the ultimate authority to amend any provision of the Constitution, including the fundamental rights. This was said in the this was said by the Supreme Court in Sajjan Singh case. So the same 17th Constitutional Amendment Act was again challenged in Golaknath case. Here we have seen there are two such provisions under 17th Constitutional Amendment Act of 1964. There are two such kind of provisions. One is the definition of estate under Article 31A. So Article 31A dealing with the definition of estate. So 17th Constitutional Amendment Act has expanded the definition of estate. The second thing is it included 44 land reform laws into the ninth schedule. So during that period of time, the ninth schedule is providing a kind of legal immunity to all those laws which were included into it. It was there from 1951 till 2007. There was a legal immunity that was granted to the ninth schedule. But in I.R. Coelho versus State of Tamil Nadu, we have discussed that in I.R. Coelho versus State of Tamil Nadu of 2007, the Supreme Court has said that judicial review is a part and parcel of an essential element of the Basic Structure Doctrine. By providing such a kind of legal immunity, or by providing a kind of blanket immunity from judicial review to all those laws which were included in the ninth schedule, is against the aspirations of the Indian Constitution and is actually destroying the Basic Structure Doctrine. So the Supreme Court has said that all those laws which were included into the ninth schedule after the 24th April 1973 will be open to judicial review. So this was we have seen. So during that period of time, under 17th Constitutional Amendment Act of 1964, 44 laws were included into ninth schedule. One such law was, so in Golaknath case, one such law was challenged. That is Punjab Security of Land Tenures Act of 1953. So the legislation which was enacted in 1953, that is Punjab Security of Land Tenures Act. Punjab Security of Land Tenures Act of 1953. This was included into the ninth schedule to give legal sanctity, to give legal immunity to this particular legislation. This legislation was included into ninth schedule. So here Golaknath, Henry and William Golaknath. So they actually challenged the inclusion of this particular law into the ninth schedule. Got my point? They are the landowners, they are the landlords. They challenged the inclusion, or they actually challenged the inclusion of this particular law into the ninth schedule through the 17th Constitutional Amendment Act of 1964. Through that particular legislation, through the particular Constitutional Amendment Act, 44 such laws were included. They actually challenged this particular law because it affected their fundamental rights. They actually saying that it affected the inclusion, or the provisions of this particular legislation affected our fundamental rights. They are saying that Article 14, Article 19, 1 of F, and Article 31. These are the rights that were affected because of the provisions of this particular legislation. And now this particular legislation has been included into ninth schedule, and the inclusion has provided legal immunity to this particular legislation. So in the court of law, the provisions of this particular legislation cannot be questioned because it was included into the ninth schedule through 17th Constitutional Amendment Act of 1964. So this was their point of argument. Whatever the provisions are there in this particular 1953 legislation, they are actually affecting our fundamental rights. Fundamental rights of 14, 19 of 1 of F and 31. These are affected. And through the 17th Constitutional Amendment Act, that particular legislation was given legal immunity by placing into the 9th schedule. Got my point? So here again the same question. Here again the same questions are repeated. Here again the same questions are repeated. Here question 1 is under Article 368. Under Article 368, does the Parliament have the authority to amend any part of the Constitution, including the fundamental rights? So the same question was repeated in Shankar Prasad, in Sajjan Singh, and also in Golaknath. So under Article 368, does the Parliament has the authority to amend any part of the Constitution, including fundamental rights? Question 2 is, are the Constitutional Amendment Acts fall under Article 13 of 1? Article 13 of 1 deals with the definition of law. Article 13 of 1 deals with the definition of law. So the question is, are the Constitutional Amendment Acts fall under the purview of Article 13 of 1? These are the two questions which were there even in the Sajjan Singh case and also in Shankar Prasad case. There the Supreme Court has said that the Parliament under Article 368 is having ultimate authority to amend any part of the Constitution, including fundamental rights. In both the cases, Shankar Prasad and Sajjan Singh. And for the question 2, they are saying that Constitutional Amendment Acts are altogether different legislations. They are different from the ordinary legislations. And Article 13 of 1 deals with only ordinary legislations. Article 13 of 1 deals with only ordinary legislations. This was a stand that was taken by Sajjan Singh case or Shankar Prasad case by saying that Constitutional Amendment Acts are different legislations and they are not ordinary legislations, and Article 13 of 1 deals with only ordinary legislations. By saying that, the Supreme Court has said that Constitutional Amendment Acts do not fall under the category of Article 13 of 1. By saying that, they said that even though the Constitutional Amendment Acts, they affect the fundamental rights, they cannot be declared as unconstitutional or invalid. So now the same questions posed in the Golaknath case also. For this particular question, the Supreme Court has said that, for the first time, the Supreme Court has mentioned that fundamental rights are immutable in nature. Immutable in nature. That means they are sacrosanct. They are sacrosanct. They cannot be amended. So they cannot be amended. So for the first time, the Supreme Court has taken a view. For the first time, the Supreme Court has taken a view that is saying that fundamental rights are immutable in nature or sacrosanct. Sacrosanct. So they cannot be amended by the Parliament. They cannot be amended by the Parliament. So for the first question, the answer is under Article 368, the Parliament is not having the authority or the power to amend the fundamental rights. The Parliament is not having the authority to amend fundamental rights. This was the answer actually given by the Supreme Court. So in relation to the question 2, the answer of the Supreme Court was, in relation to the question 2, the answer of the Supreme Court was, the Constitutional Amendment Acts, actually fall under the purview of, fall under Article 13 of 1. Article 13 of 1. Earlier in Shankar Prasad or Sajjan Singh, the Supreme Court has taken a different view. There they said that, the Supreme Court has said that Constitutional Amendment Acts are different. They do not fall under the Article 13 of 1. But now in the Golaknath case, a different stand was taken. The Supreme Court has said that the Constitutional Amendment Acts are also part and parcel of Article 13 of 1. Part and parcel of Article 13 of 1. So whenever they are part of Article 13 of 1, then Article 13 of 2 comes into play. Article 13 of 2 comes into play. So whenever the Constitutional Amendment Acts, they fall under Article 13 of 1, Article 13 of 2 will apply to Constitutional Amendment Acts. Got my point? So here there are two clauses in Article 13. Clause 1 defines the term law. The clause 1 defines the term law. Whenever Constitutional Amendment Acts fall under that definition, whenever the Constitutional Amendment Acts fall under the definition of law, then Article 13 of 2 will apply to Constitutional Amendment Acts also. The Article 13 of 2 will apply to Constitutional Amendment Acts also. Article 13 of 2 is saying that whenever there is a law that was enacted by the Parliament and it is affecting the fundamental rights, then that particular law will be unconstitutional or invalid. So in the Golaknath case, it is said that all the Constitutional Amendment Acts are also part and parcel of Article 13 of 1. Whenever they brought under the purview of Article 13 of 1, Article 13 of 2 will automatically apply to Constitutional Amendment Acts also. So here my point is, whenever the Constitutional Amendment Acts affect the fundamental rights, they can be declared void, they can be declared invalid, they can be declared unconstitutional. Earlier, the case was different. In Sajjan Singh or Shankar Prasad, the Supreme Court has said that Constitutional Amendment Acts do not fall under the category of Article 13 of 1. So, whenever they do not fall under the category of Article 13 of 1, there is no question of applicability of Article 13 of 2. So, they are outside the purview of Article 13. So, Article 13 of 2 did not apply at that point of time. Under Shankar Prasad or under Sajjan Singh, Article 13 of 2 did not apply to Constitutional Amendment Acts. But now, in the Golaknath case, it is declared that by the Supreme Court that Constitutional Amendment Acts fall under the purview of Article 13 of 1. Whenever they are coming under the purview of Article 13 of 1, automatically Article 13 of 2 will apply. Article 13 of 2 is saying that whenever the Constitutional Amendment Acts affect the fundamental rights, they can be declared unconstitutional or they can be declared invalid. So here my point is to stress is that whatever the stand that was taken in Shankar Prasad or Sajjan Singh, that was totally overruled. That was totally overruled in Golaknath case. Got my point? Right. So the Golaknath judgment was given by a 11-judge bench. 11-judge bench with a 60-5 majority. 60-5 majority. So whatever the pronouncement of the judgment in the Golaknath case by the Supreme Court, which actually overruled earlier judgments such as Sajjan Singh and Shankar Prasad. Got my point?